Welcome to the Law Dad Roy podcast, featuring trial dad and trial lawyer Roy Willie. Join us as we break down the biggest cases, the legal strategies that shape justice, and the stories behind the courtroom victories. Whether you're a legal pro, a curious mind, or just here for the ride, this is the podcast for you. Let's talk law. Let's talk justice. Let's talk winning. And now from beautiful downtown Charleston, South Carolina, here is your host, Law Dad Roy Willie.
All right, Matt, so we're back. Part two of the Brittanee Drexel podcast. Today, we really intended actually for it to be a one-part thing. We were going to talk about the trial, but we got so caught up really talking about Dawn and her story and commitment to her daughter last time that we actually, they told us afterwards, we never really talked about the trial. So that is why we are here. Just to give, I guess, a little bit of background and remind you, but this case, so the case was filed originally in January of 2023 by another lawyer friend of mine, filed it. The cause of action was just for Dawn's emotional damages, so this is not the wrongful death case or the survival case for the estate of Brittanee Drexel. Those actions are pending in Richland County and are still ongoing. This is a very narrow case that was filed, just against Raymond Moody, just for the emotional damages of Dawn Conley, the mother. And it was filed in January of 2023. We tried it in February of 2025, which I guess tells people most of what they need to know about how long something like this takes.
Yeah, and that's pretty much par for the course, I would say, as far as the filing date and then later the actual trial date. In most cases do take 2 years to get to trial, the ones that go to trial.
Yeah. And importantly, in this case, we didn't have a whole lot of pushback on trial dates or anything like that. We were able to try it when it came up for trial, pretty much the first time, pretty much immediately.
Yeah, it was interesting also, aside from this trial being specific to Dawn's emotional damages, that the person on the other side is a convicted murderer who's serving a life sentence and was not represented in this trial. So we didn't have a whole lot of pushback from him as far as scheduling. It's brought him over from the prison.
Right. And so I guess that's kind of a word to note for everybody. Even under those circumstances, it took more than 2 years to get the case to trial. Tells you about sort of the backlog in our court system. Mm-hmm. So for those people that have cases out there where you feel like it's moving slowly, just know that is pretty normal. I mean, here's a case that basically didn't have a lawyer pushing back, trying to get more time to build more hours on the other side, and still a little bit over 2 years in order to get the trial. So
right,
pretty good amount of time. You mentioned. One thing that was kind of weird about this particular trial is that Raymond Moody was not represented by an attorney in this case. He was representing himself. Obviously, everyone, I think, by now knows that he was incarcerated. And so they actually, there's some special things that we had to do in order to get him there. Typically, the lawyer on the other side is responsible for getting the client there. You can't have convicted murderers just inviting themselves to every trial that they want to attend. So there's actually kind of this interesting process that we had to go through, for that. And I don't know if you had ever experienced that, before, maybe in criminal court, but.
Yeah, in my past life as a criminal defense lawyer, we had that situation on a few occasions, but had to get an order from SCDC for his transportation on both days, which there was actually a delay the second day of trial because they didn't bring him, so we didn't start until lunchtime.
Yeah, the second day. So we get this order from the court. It's called an order of transport. We have to coordinate. The court doesn't. We have to coordinate with SCDC. I believe the lady's name was Angela or something, in order to get him transported. He was, I believe, in McCormick maybe by this point. Anyway, he comes to Kirkland, which is in Columbia. They're transporting him to Georgetown. First day, we had checked in on Friday just to make sure everything was a go. They said it was. They got him there at 9 o'clock, no problem. For whatever reason, they didn't leave him in Georgetown lockup. They transported him back to Columbia, which is over an hour away. And then I guess on Tuesday just forgot that he needed to come back. So I get a text message, on Tuesday morning from FBI agent Mike Conley, who was a witness in the trial, and he said Ray has his number because they've been talking about the criminal side with Angel Voss and all this. Anyway, Ray calls him from Kirkland to say, hey, they didn't come and pick me up. I've been ready, and I don't really know. I just don't want the court to think I'm not showing up. He has no ability to show up or not show up or whatever. So anyway, I emailed the judge or whatever and copied you because we also have to drive. We're driving from, Charleston to Georgetown. We didn't stay in Georgetown for this trial. We were riding together, but, we said, well, I guess we have to get there. I don't know if they're going to, put him in a patrol car and, blue light it all the way down, 26 or whatever to get to Georgetown. Maybe he'll get there on time. Turns out he was not on time the second day. He was there about noon, which was really problematic, as you know, because my entire household of 4 kids and wife were sick.
Right.
We had got back from a Disney cruise, and at least 2 of them had contracted norovirus. I had been very careful not to interact with them and not to do anything that would lead to me contracting it. But it was pretty clear on Tuesday morning that I had. And so I thought, well, maybe we'll get there at 9:30, we'll give closings, and it'll be all good. But that obviously was not the case. And so day 2 was particularly painful for me. I think I spent more time in the bathroom than I did in the courtroom. But anyway, we got it done.
I just texted you to say the judge is back.
The judge is back, and so back I would come. But they did get Ray there. We were able to proceed forward, with the trial, and I guess backing up kind of to day 1. One of the weird things, I've had this twice now where trying a case and there's no lawyer on the other side. I don't know what your sense or thought on it is. I actually find it more difficult to try a case against a pro se defendant. I mean, what are your thoughts on that?
I think the conventional wisdom, so to speak, would suggest that it's easier, but I agree with you that it's in a lot of ways more difficult because you have no idea what to expect.
Right.
When you've got a lawyer on the other side, you know that they're going to object to this and that. With just a convicted murderer who's serving a life sentence on the other side, you don't know what to expect as far as the more basic legal ins and outs that you would have in a regular trial. Yeah. And that was made even more complicated by the fact that we didn't know coming in how Moody was going to conduct himself. There were some messages between himself and Angel Voss while he's been incarcerated where he was saying, if they drag me through the same thing at the civil trial, then I'm going to, tell everybody to shut up, basically. And as it turned out, he came in and expressed remorse, whether or not that was sincere.
Right. I think the interesting thing, on the pro se piece too, is that the judge, rightfully so, I feel like, feels a heightened obligation to protect the pro se party, right? So like in a normal trial where it's lawyers duking it out, typically, unless it's certain judges, you're not going to have a judge that's objecting for the other side or saying, hey, dial it back, or saying, hey, what about this? But literally, I mean, in this case, when we showed up on Monday for a roster call, the judge's first thing is, well, why don't you waive your right to a jury trial? I mean, a 7th Amendment right that our client has in a civil case, a right to a jury trial. Kind of the first question out of the gate, which he's entitled to ask. I'm not saying he should not or faulting him. I'm just saying that when you have that set up throughout the trial, the judge is also trying to think of ways to make it go faster and to make it fair, for the pro se party. And in this case, I mean, literally right out of the gate, was that question. Well, why don't we just do a bench trial? And we were prepared for that. We had talked to Dawn about that. Dawn has been pretty clear about what this case is about. And this case for her has always been about the community recognizing what happened to her daughter, what she went through, but also sending a message that if other people do this, they will be held fully accountable in every possible way. No stone left unturned, and full justice, as she calls it and we call it. So anyway, we were prepared for that, but that was just one wrinkle. I mean, you don't have that. I mean, you ever showed up for a trial where there's a lawyer on the other side and the judge suggests that your client waived their right to a jury trial?
Right.
I mean, it doesn't happen. It doesn't happen. So,
no, it doesn't.
Yeah, so that, that was interesting. And then, so once we got through that and Judge Hyman understood, Dawn's position on that and, was good with it. And by the way, great judge, I thought that, given the, sort of odd nature of the setup of the case, having a pro se defendant and a very highly publicized case, which by the way, Moody has had lawyers throughout the course of time, right? So he's been represented. He just was not represented in this particular trial for whatever reason, and we'll get to that. I actually think to the extent it was a strategic decision, it's a pretty good one, I think, actually. But Judge Hyman, we go through that, and then we're going into the jury, and we have all of these media journalists, media outlets that have requested to be present at this trial. I mean, all the way from local news blogger to Fox News. It's kind of across the spectrum. We have people that have asked to come in. And so Judge Hyman now has to deal with that, right? That's not a normal thing. And that, gets us into jury selection, which was really pretty contentious, I felt like.
Yes, as far as him telling the media that they had to leave, which I don't know what your opinion is on that. I actually, I liked Judge Hyman's decision on that. The jury pool, these are people who are taking time out of their day to do their civic duty and show up to be a juror. And, they don't want to be on the news. Right. And I kind of agree that they shouldn't have to be, so. Yeah, no, I agreed with him on that too. I mean, his position, first of all, let me be clear. My general take, and I think what the law is that the courthouse is a public forum, and anything that happens, in the courthouse is public. And of course, people can come down and participate in that and watch that and whatever. His concern on jury selection was that if the media was present, people may not be as forthright in some of their responses. For fear of that being publicized. So, just for example, I mean, one of the questions is, has anyone here ever been convicted or, charged with a crime, convicted of a crime? There's all these questions about this. And he had a concern that, well, maybe people won't be as forthright if they know they're going to be blasted or think they're going to be blasted on the news, as answering that. So, I totally agreed with that. And I think the media more or less understood it, whether or not they agreed with it. But they certainly did not agree with it in the beginning, and they did not understand it in the beginning. There was some very, there was a lot of banter and shouting about this is illegal and our, First Amendment and all this sort of stuff. Yeah, I think once they realized that they could come back in 30 minutes to an hour, then
right, they
were fine. But
yeah, that was, so that was different. Say every trial you kind of learn something, you see how it goes. That was different. But we got through that. We got into jury selection, and there are some personal questions. One of the questions was, does anybody know anything about this case? And I don't know if you were surprised by the response to that, or not, but it was. That was different as well.
I thought everyone would know.
Yeah, and they didn't.
No.
They didn't. They didn't. This was a case where, this girl's face had been on, literally billboards, the news, flyers, everything, throughout this community. And I don't know, do you have a sense of like what percentage stood and knew something about it?
I would say it was less than a third for sure.
Yeah, it was, I thought it was pretty, it was pretty small, pretty surprising actually. But that was good because one of the judge's concerns that he also raised to us, before that was he was not sure that Mr. Moody could get a fair trial in this venue, which is a concern, but we were able to overcome that.
It was surprising. I thought everyone would know about the case. Whether he can get a fair trial, despite the fact that many of them do know about the case, I guess is a whole nother issue. I think the ones that did speak up and say that they had heard the story, so that they could still be impartial, and it was good that wasn't an issue. And I think once the judge realized that we're going about this the right way, and essentially that this wasn't going to turn into kangaroo court because we have all this media and we have a convicted murderer pro se on the other side.
Right.
At that point, he was more relaxed about what was about to go on.
Yeah, and I think put him at ease when we told him what our trial plan was, which was not. We could have been in there for 4 weeks. Over the course of 15 years, the number of witnesses, the amount of evidence, just the jailhouse messages alone, hundreds of pages, or whatever. It could have been a month-long trial.
Yeah.
We told him that our plan was to put it up and get out of there in a day. That was our plan. And we almost did. We could have, but he did not want to risk keeping the jury too late. So we came back on day 2 for closings and deliberation, which is okay, which was fine. Other than I had to apologize to the jury because I told them in opening, a good lesson, don't make promises in opening you can't keep. Although I did make a promise. I said, our goal is to get out of here in a day, and we're going to do everything we can to move it along. And we did. We really did try to get it done in a day. Because, once we kind of realized what the posture of everything was, we want to be respectful of everyone's time. And we also had other ways to present evidence in order to streamline things. And candidly, I don't know why lawyers don't agree to things like that more. Essentially what we did is we put together a day in the life video, which was taken from footage that 2020 had done, but that we could have produced if they had not already done it. And in lieu of calling witnesses and having them get up there, one by one and say who they are and where they're from and how they're involved and then get their testimony, we were able to really move through it, just taking about an hour worth of various witness testimony and video format, and then using that, because we did that in opening, using that with our first witness, who was a part of the entire case, Mike Connolly, to say yes, everything you just saw was accurate, based on what I know and what I saw and what happened here. So it would have been admissible, by the way, in any trial, whether he was defendant or not, in my view. But every lawyer, I shouldn't say that, most lawyers would have objected to that in the opening and say, well, this is beyond, what they should be allowed to do. And maybe we would have been able to play it, maybe we wouldn't. But I think that helped a lot.
I think it did too. It made the trial far more succinct than it otherwise would have been, but I also think it was more effective. Even if some of the jurors had heard the story over the years, they're certainly not familiar with it on the level that you and I are, having worked on it for an amount of time. And being able to watch the story on a screen and then hear from people who are in that footage, it laid it out really nicely, and did it in a way that made sense.
Yeah. No, obviously I agree. I think that part was good. We had, the jury was very attentive. We ended up with jury of 12 in South Carolina. Jury has to be unanimous on whatever they decide. Trying to get 12 people in America to agree on anything is very difficult, but obviously we have the burden of proof. We had 11 females, one male on the jury. So, jury looked, like we would want the jury to look for a case like this, and they were attentive. So we start the case, we do that in opening. I think that I agree with you. I think it was effective. I think the jury appreciated the fact that they felt like they were getting a shortcut. Because when I said in opening, we could bring in X number of witnesses and show you all this evidence, you begin to see the weight lift off, oh, thank goodness, we're not going to be here forever. Because they also know it was a serious case, and typically with a serious case like this, it does go on for a while. So we did that, and then we got right into witnesses, and really 3 witnesses. Who did you think were? Well, I shouldn't ask that. I guess from Mike Connolly's testimony, what did you find kind of most compelling about what he had to say? I mean, this was the FBI agent that basically cracked the case. I mean, for lack of a better term, him and his team.
Right.
Really committed guy. What did you find most compelling about his testimony?
I thought all of it was really interesting. The way that they had some surveillance footage of this one particular stretch of road that they knew Brittanee was seen on last, essentially, and they spent months and months going through that surveillance footage, looking at every single vehicle that passed along this road, looking at make, model, color, license plate when they can see it, who's driving, every detail, and eventually led them back to Ray Moody, who was he was a person of interest at the outset of the case years and years earlier, before the previous FBI team went down another path that basically led them nowhere.
Right.
And when Mike got involved years after that, his team did the due diligence and a lot of tedious work, quite frankly, reviewing all that surveillance and just trying to figure out who's in all of these cars.
Right.
But all of that was really interesting, and then at some point, Moody realized that they were onto him, and that his time was up, basically.
Right.
And he came in and confessed, but at that point they had to do more work to corroborate everything he was saying. It's even though he's confessing to the crime, they've got to make sure that what he is telling them is actually truthful.
Right.
Especially the important parts.
And it was evident that he was really making a deal. He was really confessing in order to make a deal to try to save his girlfriend.
Right.
At that time, Angel Voss, basically. So they had to corroborate all that. I think, Mike's a very direct guy. Worked with him, over the course of this case, and real kind of asset to America in general. Really just a really good investigator. I thought what was, for me, most compelling about his testimony is when he basically said, well, the reason we saw this was because of Dawn. I had a small role, but it was really her persistence. And I thought that was, says a lot about his character, obviously a lot about Dawn.
Right.
But that was, I thought that was good. That was special. And Mike stayed for the whole trial. Came back the next day and he was there.
He was not just an FBI agent or a cop showing up for trial. He was someone who, at this point, was very personally invested in the outcome. And very connected with Dawn and the family. Yeah,
he's been at every sentencing. Just really involved the whole way through. But his testimony, I think, was key because he was able to corroborate everything in the opening in the video, and the jury, he's a very credible person, obviously. The jury, was then able to accept that. It's like, okay, this is not exaggeration or whatever. Like, this is actually what happened. Like, these people, they're out there with like a backhoe, like digging this girl up in the swamp. Like, wow, it just kind of blows the mind. But so then, we had two other witnesses. Obviously, we had Kimberly Kite, who is now basically, I think she referred to Dawn as basically like a sister to her, but she got involved in this really from the investigation standpoint. She runs a foundation that works and former law enforcement, and they work on missing persons cases. And Kim was able to talk about what she had seen in Dawn throughout the course of this, emotionally, in terms of what it took out of her. And I thought that her testimony was really compelling, because what we never want, I always say this, like, we have a case to prove, right? We have to prove that there was actual emotional damage. We have to prove by a preponderance of the evidence that, that damage has like some monetary value that can be assigned to it, that is worth something. And the best people to prove that are the people that have suffered it generally. But nobody likes a whiner, right? I don't like a whiner. You don't like a whiner. People in the jury don't like a whiner. I don't like when my kids whine. I love my kids. Give my kids anything in the world, but I don't like when they whine. I tell them to stop whining, right? It's just a thing. Don't whine. So you can't, I believe that you can't have the plaintiff, you can't have the person that actually suffered the damage up there telling their story by themselves, because it can be perceived as whining, right? They're there essentially asking for money. That's all we can get. That's all the cases can be about. We don't do eye for an eye justice. That would be barbaric. We trade eyeballs for money, which might, in some senses be more barbaric. But anyway, that is the way that it goes. So we have to, we've got to find a way to show that without Dawn being up there, crying and going through kind of, everything that she's been through, and also really to protect her, right? I mean, I don't want her to have to be up there for 3 hours crying and suffering additional emotional damage, going through this trial. So that was really the purpose of Kim. And I thought Kim did a good job with that,
I thought she did too. Mike as well. It was good leading with Mike, because Mike he doesn't speak emotionally. He speaks right to the point.
Right.
He's discussing facts. So he did a good job of explaining the case and what happened and his work on it. And then when he talked about Dawn, he said, she's been in constant communication with us, never bothering us.
Right.
Just she was on a mission to find her daughter.
Yeah.
And then Kim did a good job of just further emphasizing that, one, Dawn is a powerful, strong woman for this fight that she has put up for the last 13, however many years, but she's also exhausted.
Yeah.
And I thought Kim did a good job of touching on that.
Yeah. No, 100%. 100%. And really, set it up nicely where we don't have to go into all of that with Dawn. I mean, Dawn, I think people's perception, because of what they see on TV or what they hear about, trials, is, the plaintiff's going to be like the longest witness we're going to have to hear about all this. Dawn was the shortest, probably. I mean, I didn't have a stopwatch, but, very, very short, just to tell the things that only Dawn could tell. Tell us about your relationship with Brittanee when she was growing up. And your relationship, with Brittanee at the time that she was kidnapped, and to go through, some of those things. And candidly, we had some things, in this case that, the other side would love to harp on that we could have left out of the story, right? Because there was no lawyer over there who was going to cross-examine and bring these things out. One of them being the fact that, Dawn had specifically told Brittanee she wasn't allowed to go to Myrtle Beach for spring break. And like, any other resourceful teenager, she figured out a way to go, despite what her mom said. You know, and we could have kept that from the jury, but everyone that I have heard from about this case or talked to, they don't care about that, right? Because people know kids do things that we tell them not to do all the time, and that doesn't mean that there should be, you know, a life sentence associated with that. You know, that she should be raped and killed because she didn't listen to her mom as a teenager. I mean,
Exactly.
everybody, you know. And so we brought that out in opening and brought it out again with Dawn, you know, and Dawn said, absolutely not. I told her, no, you cannot go, you know, and Dawn is adamant about that. And, you know, it's just one of those things that I think was important in the way that it allowed the full story to be told, but also to give Dawn that resolution, that knowing, okay, even with this told, it doesn't matter, you know, because that's what I always told her is it doesn't matter to people. That's not what the story's about. You know, and so we brought that out through her, you know, and, you know, that, you know, I was watching the jury kind of during that exchange because just because, you know, this focus group or this group of people think it, ultimately we got a jury. And it doesn't matter what anybody has told you before. Like how they react to it is what matters, and you know it was a big nothing burger. I mean, I was watching; they were just like, yeah, well, of course.
My kids don't listen either.
Yeah, it's like, you know, it was very, you know, it was fine. And if anything, I think they appreciate, you know, that you own that. You know, that you do acknowledge that this was wrong. You know, and that's why I say, I don't know what your thought was. You know, we get through Dawn, and then obviously Ray has his opportunity to present whatever evidence he wants, and he didn't present evidence, but he did make a statement. You know, during the trial, as part of you know, his statement to the jury, and basically just owned it. I mean, he owned it. You know, he essentially said, "I did what they say I did. There's nothing I can say to make it better, and I understand that." And I forget exactly the words he used. We had to roll the tape back, but some version of "I'm sorry."
Yeah.
And I know no amount of words or sorry is ever going to be sorry enough. You know, and I thought in a weird psychopathic way, like that's the perfect way to try that kind of case.
Yeah. Yeah.
You know, and I don't know how often you've seen defense lawyers do that.
No.
Never.
Yeah. If you had a lawyer, that wouldn't have happened. And
no, and the verdict would have been worse, I think, candidly. I mean, I actually think that the verdict was lower than it otherwise would have been if he had put up a fight.
yeah.
You know, and so that's why I say I think that was I think that's a smart strategy. You know, you own it. You say, I'm in prison for the rest of my life. I deserve it. No amount of sorry is enough. And the jury thinks, well, okay, well, what are we doing here? You know, let's just get a little bit of closure and get out of here. You know, and we didn't tell the jury necessarily what they should award, but in my closing, I gave them a way to get to $1 billion, right? Like that's the number we talked about, and they didn't award it.
No, they shorted us by $300 million.
Yeah.
No, I thought your closing was great. As far as basically just telling them what realistically will be recovered based on any verdict that they bring us, and you know what we're asking for isn't what we're getting. Just telling them that up front. Ray Moody inherited some land from his dad when he died, which I understand is somewhere between $300,000 and $400,000 worth of land in Georgetown County. So Don will be able to recover that, but. Otherwise, unless Ray Moody's just playing the Powerball in jail and wins about 3 times, she's not getting $700 million.
Right.
So I thought you did a good job of explaining that.
We support, by the way, Ray Moody being able to play the Powerball in jail. If anyone at SCDC is listening, please
tell him to use all his commissary on lottery tickets.
We support that.
But no, I thought that did a good job of letting the jury know that what number they come back with is really sending a message. And you you pointed out that this number should tell everyone that if they come to Georgetown County and do what Ray Moody did, whether they're someone of limited means like Ray Moody, or if they are a billionaire, which we've seen plenty of stories in the news where billionaires do these sorts of terrible things too on occasion.
Right.
You're telling them, here's a number that says no matter who you are, don't come here and do this.
Yeah. If you come here and if you inflict this harm, you will pay for the damage, right? And you're allowed to say that, right? So what you when you're talking about punitive damages, you can just talk about sending a message generally. When you're talking about actual damages, we have to talk about sending a message that the full amount of damages will be paid. That's the message, right, that we're sending, is that whatever the damages are, the actual damages, they will be required to be paid. And we talked through that, and people ask, they're like, well, how do you put a money amount on what this woman went through, what Dawn went through? Well, you can't. It's impossible. To put an exact figure on that. And the jury charge says that. It says, you can't reach a number on mental anguish to any sort of mathematical certainty. Like, there is not an equation you can use. You just have to use your good common sense. And essentially what the question is from my perspective, how I see it is, what amount of money, would you expect this person to trade to go through what she went through? And even when you do that, the answer is like, there's no amount of money that she would trade to go through what she went through, right? She would give, even if she got $700 million, she would give it all back, to not have to go through that. But in our system, you've got to get as close as you can. And here the jury, I think, really considered everything, and they came back with $200 million in actual damages, $500 million in punitive. Which was a very reasoned and rational ratio, and probably a little low on the number. I mean, if we're being honest, but again, no number would ever fully compensate Dawn for everything she's been through. So
yeah. It would have been interesting to be a fly on the wall in the jury room, as it would be in any trial, particularly in this one. Deanna and I talked about it the night before, and I said, if I were on that jury, I'd say let's write as many zeros until the point where the court's not even going to know how to say the number, and then send the form back. But I thought that they came back with a reasonable a number that does send the message that they wanted to.
Yeah, and they took it seriously. They were very complimentary after the trial, and of course, we appreciate that, because you never know, was it too little? You put up this very serious case in a day and a half, and it certainly crosses your mind, like, if we don't get a good result, like, you would start thinking, I'd think about all that in advance. So I leveled with them. And I said, I hope that if that's the case, then you will hold that, hold it against us and not Dawn, because it was a big decision. It's a big decision to do that. It's like when we tell clients, I have clients that say, I think we should not put your medical bills into evidence, because your medical bills are not what this case is about. This case is about is that scar on your face, or that, the broken leg that you walk in with a limp. It's not the cost of the cast that that's what it's about. So when people put that kind of trust in you, I think it's natural to have a little, I won't call it anxiety, but second guessing about is this the right move, is it not? I mean, we talked about it a lot. How do we do this? Because obviously one choice is you can call the witnesses. And there's a theory of thought out there that, well, if you have a very long trial with a lot of witnesses and all the news cameras in the first row of the gallery, people will think that is a more serious case than a case that, you come in and you put up in a day and a half. And maybe they feel like you aren't taking it seriously or something. You don't know.
Yeah, and I think the jury appreciated the way that we did the trial. I think if we had put up witness after witness, they would have looked at it and said this is excessive.
Yeah. Yeah, well, maybe we'll have to look into the rules and talk to ethics counsel. But they were a very friendly jury. Maybe we can have one or two of them, on the podcast, and they can give us some insight on what they saw and what their thoughts were. I don't think there's anything wrong with that. But if they want to do it, but we'll get it cleared before we reach out. But this has been great. $700 million verdict. You don't get those all the time. And as I said to the media afterwards, this is the type of case with the types of damages that require that verdict. Not deserve that verdict, but they require that.
Yep.
What Dawn went through requires a verdict like that. And so, of course, the jury saw that and, appropriately valued it. And we're thankful for them, thankful for Judge Hyman, for keeping it, between the lines, and, thankful to you for coming down the foxhole with me.
Yeah, same to you. I enjoyed trying the case with you. I look forward to the next one.
All right. Good to see you.
Good seeing you.
Thank you for listening to the Law Dad Roy podcast. If you have any questions for me that we can talk about on the pod, follow us, DM us on Instagram, reach out on Instagram. We're at Law Dad Roy. You can find us there on YouTube, Facebook, wherever you decide to connect. We look forward to hearing from you.
Law Dad listeners, next week we're diving deep with PWA Chief Growth Officer Chris Covert, where he and Roy will chat about the lie known as work-life balance. We'll talk burnout, boundaries, and why chasing balance might actually be what's throwing you off. Trust me, you don't want to miss it. See you next, and every Monday at 9 a.m. Eastern Standard Time, wherever you find your podcasts.